Hello, hello, everybody. How are you doing? So, today we're here to talk a little bit about one of Zellner's clients that is a case I've been keeping my eye on because I saw some of the kind of what I looked at as kind of BS going on in it back when I looked into it back over a while back, basically. That is the Melissa Calusinski case. Sorry about the background noise, guys. I got the fan going because where I am, it's actually a little bit warm. So apologies for that. And yeah, this is one of Zellner's cases. This is one that's really near and dear to her. She tweets about it quite often. It's one that she really cares about, and I think it's an interesting case of the prosecution once again just showing that they can just get away with just about anything. That they have no fear, and so it's just really disturbing to see, honestly. We were posting disingenuous Wisconsin on this morning's live. Uh, Allie's talking about Rolls songs there. So the thing about Melissa's case is okay. She worked for like a daycare center. Okay, and one day one of the kids turned up. He had pretty bad like injury to the back of his skull, and it got pinned on Melissa. They brought her in and interrogated her for quite a long time. She resisted for a long time, and then eventually they basically got her. They basically got her to acquiesce to saying what they wanted her to say, their narrative that they came up with completely, not from her. And she eventually gave in. It's sad, really. She eventually, but the things that end up coming in are interesting. You're going to see. We're going to read a little bit about it today in the motion for habeas relief. But you're going to find out things like this kid. Unfortunately, this kid had a history. There were witnesses that had seen this kid as like in reaction to, I guess, when he didn't get his way sometimes, or when he was mad about something, he would like fall to the ground and hit his head, the back of his head on the ground. And so they've now looked into this, and the x-rays and everything, the original ones, the ones that weren't doctored and corrupted by the prosecution before being sent over to the defense, the JPEGs. And you're going to see there's a lot of talk about this, the difference between the JPEGs and the TIFFs and all that stuff. It's all important to understand the games, that the Brady games, hashtag Brady games, that the prosecution was playing in this case. So it's very interesting. But these exams show that this child had a pre-existing injury. And then there is a witness that says they saw this kid fall and hit his head, the back of his head, previously. And that, so there's a history. So then, you have the fact that the prosecution was hiding the really high quality imagery of the x-rays and everything of who they call BK in this motion. They were hiding the really high quality ones, and they ended up making some really poor quality. And she goes through with her expert in this, guys. You're going to see her expert goes through exactly everything he has to do to produce the pretty much the same exact quality that was handed over to the defense. He shows how he had to take a JPEG from the TIFF at really low quality. He had to make the width of the frame 3 when it should have been thousands, like all these things. Then he had to do another. Then after making that JPEG, he had to put that back into the editing software. Then he had to make another low quality JPEG image after doing some other things. That is how he produced so basically what the defense got, what Melissa's defense got in terms of this child's injuries was highly doctored, multiply doctored, is what it basically shows, because that's the only way they were able to get the quality that they see was handed over to the defense back in 2011. And they have proven that these high quality TIFF images existed at the coroner's office in 2009 and were still there in 2015 when they were discovered in post-conviction, investigation and stuff like that. They were then turned over and stuff. And now the experts are being able to examine those and say, yeah, this kid doesn't have a skull fracture. There's no skull fracture. He had a pre-existing injury, and it was healing, but it looks like it may have been hit again and aggravated or something. But it doesn't look like it was blunt trauma or anything violent. It looks, because due to the fact that there's a witness that says that this child had, fallen back and banged his head before, it would suggest to reason that might have happened again. So when you find out that the prosecution was playing games, hashtag Brady games, with these images, it's very interesting. Hello, basically a lawyer. Hello, Tracy. Hi, Shireen Grant Stewart. Nice to have you. They got into her head, yeah. I haven't had the chance to read Melissa's petition yet. I've been meaning to, just haven't gotten around to it. Yeah, I was just reading it today, and it's interesting. I mean, it just lays out two main things on federal habeas here. They're basically saying that her due process rights were violated because of all the games being played with the images and the fact that they existed at the coroner's office in 2009, yet the inferior JPEG images that were highly doctored were handed over in 2011, and then they ended up finding the TIFFs, the very high-quality images, still at the coroner's office in 2015, creating this whole problem now with Brady, because if those were there in the first place, why were very poor quality JPEG images being handed over to the defense, and that sort of thing? It's just raises. So that's one thing that they're going through, and then the other thing is that they're basically talking about how if Melissa had these things, then she would have been able to essentially refute or to to impeach the prosecution's expert, the Dr. Chai, I think his name is, that they would have been able to impeach him because he claimed there was a skull fracture, that he felt it with his finger or whatever, because nobody but the prosecution had the really good x-rays that showed that there was no fracture. What was sent over to the defense was highly doctored and dark, and nobody could tell anything about what was on them, and they put it this way: the JPEG compared to the TIFF was like comparing Crime and Punishment to its Cliff Notes. So imagine Crime and Punishment, and then imagine the Cliff Notes for Crime and Punishment. The JPEG is equivalent of the Cliff Notes, right? It's missing much of the substance, and you know what I mean. So you get what it's at. You get what it's coming out there. And these JPEGs were all dark and unreadable and ridiculous, when these TIFF ones that were perfect existed the entire time. So this is relevant. It would have allowed them to impeach the prosecution's expert, would have most likely had a huge impact on the jury and that sort of thing. So this is what they're arguing. Basically, these two things: due process and the fact that this Brady violation prevented her defense from being able to impeach the state's expert. I saw a show on this case before Zellner got involved, but it's been a while. Yeah, it's anyway, it's interesting. Missing the live earlier this morning. Yeah, I know a lot of people missed the live earlier this morning. It's okay. We still love you. Let's see here. What do we got? G'day from Australia. Hey, Deborah. Let's see. Thank you for all your great videos. Oh, you're welcome. Thank you, the mods, for the great work, as well as Justice for All. Hey, thank you so much, Deborah. The investigators did a number on Melissa. She was a distraught child. She was distraught. A child died. Then these cops come in and really screw with her head. I mean, yeah. I mean, she was vulnerable, I think. She actually resisted them for quite a long time. And so it's, you just wonder, at all of it. And the fact that the facts are now coming out that this was nothing that the prosecution claimed it was. There is no skull fractures. There is no violent intent here. It looks like pre-existing injuries, and there is a witness account of this child banging the back of his head previously. And when you start to consider all the things, it's just like Zellner always says, when you start getting at the truth, everything starts to just click into place. And that's what's happening, you know? Do me a favor. Strap covering Challenger Wade. Thanks, dude. Move the strap. That's my VIP pass for the Melbourne show. I don't know. All right, I'll consider it. Melissa denied more than 70 times, but eventually broke. Right. I mean, even adults can break under that kind of pressure and heat, you know, from overzealous, you know, officers and agents of the state. Funny you should call me the dude because I'm wearing the dude shirt. Anyway. There's some video here. All right. Well, let's go ahead and look at, I'm not going to be able to look at the chat while we do this, but let's look at some of this habeas petition here. That's weird. Why is it doing that? Let's try this. Better? All right, there we go. Okay. All right, so this is Melissa's, this is basically the petition. So what I'm going to point out first is this goes through basically what's all happened before. And it started out as 4 issues that she was appealing originally. Now it's a 5th, essentially. So I'm going to go through them here. This would be from the most recent appeal she last filed with the state courts, essentially, right? That's what these grounds would be from. When we get past this, we'll see what she's filing, what basically she is filing under habeas relief too as well. So, but this is the issues that they were appealing in the state court. And so I just want to go through these kind of quick. Okay, ground 1, newly discovered evidence negated the probable cause by basis of Melissa's arrest. This evidence was composed of the medical examiner's admission that he had made a mistake during the decedent's autopsy, and missed evidence of a pre-existing injury. The medical examiner's incorrect conclusions directly affected the investigators' interrogation of Melissa. To wit, the medical examiner advised the investigators that the decedent's injury could not have occurred without a brutal criminal act. Had the medical examiner rendered the correct opinion concerning the decedent's cause of death, i.e. re-aggravation of a prior injury, not intentionally inflicting force, Melissa would not have been arrested, prosecuted, convicted, and incarcerated because no crime was committed. It is axiomatic that if no crime was committed, there can be no finding of probable cause. Ground 2. Newly discovered evidence. The medical examiner's incorrect conclusion demonstrated that Melissa's confession was involuntary and unreliable. Specifically, the investigators used the medical examiner's incorrect conclusions to discredit Melissa's protestations of innocence. Because the medical examiner advised the investigators that the decedent's injuries could not have occurred without a brutal act, the investigators were intent upon extracting from Melissa a statement implicating herself in the supposed use of brutal force against the decedent. Thus, the medical evidence upon which Melissa's alleged confession and, by extension, her conviction was based upon incorrect medical conclusions. Okay, ground 3. Timely disclosure of the medical examiner's error would have resulted in a different outcome at trial. The medical examiner was the only testifying expert for the prosecution to have reviewed the histology slides. Every other expert deferred to the medical examiner's review. That the medical examiner missed the apparent prior head injury undermines confidence in all the opinions he rendered at Melissa's trial. Basically, because every other expert attached themselves to him, and yeah, I see what they're saying here. Most importantly, Melissa's primary defense at the trial was that the decedent's death was caused by his re-aggravating an existing injury by banging his head against the ground. Had Melissa known that there was scientific evidence of such existing injury and the medical examiner failed to identify such evidence during autopsy, Melissa would have used this evidence to provide an innocent explanation for the decedent's death. Such evidence would have permitted Melissa to mount a defense that likely would have resulted in her acquittal. Ground 4. Previously undisclosed evidence demonstrated that the decedent did not suffer a skull fracture. Instead, the mechanism of death was cerebral edema caused by a prior injury and exacerbated by repeated headbanging in the support thereof. Melissa submitted an affidavit from Dr. Nancy Jones, wherein Dr. Jones averred that she had reviewed all medical evidence and, to a reasonable degree of medical and scientific certainty, the decedent had a well-developed organizing subdural membrane. This finding supported the conclusion that the decedent had suffered at least one previous subdural hemorrhage, which was in the process of healing at the time of his death. Indeed, Dr. Jones averred that the mechanism of the decedent's death was cerebral edema, consistent with a significant concussion, following cumulative incidences of headbanging. In sum, the pattern of injuries suffered by the decedent did not comport with the manner in which Melissa demonstrated throwing him to the ground in the interrogation videos. Dr. Jones also viewed the X-ray images that were withheld from Melissa's trial defense counsel. These X-rays showed that the decedent's head was shaped like an old-fashioned light bulb. It was known at trial that at the time of death, the decedent's head measured in the 95th percentile of similar-aged children. Dr. Jones opined that the size of the decedent's skull was consistent with brain swelling. However, the nature of the swelling, including its extent and the lack of separation of cranial structures observed in the previously undisclosed X-ray, indicated that the swelling was related to a prior injury, not the alleged acute injury inflicted by Melissa, supposedly. Reviewing this previously undisclosed X-ray, Dr. Jones further opined that the medical examiner identified as a skull fracture was in fact an accessory suture. Had Melissa been provided that previously undisclosed X-ray at trial, her experts would have concluded the mechanism of death was a cerebral edema arising from repetitive bangings of the head. Okay? All right, ground 5. As for the previously undisclosed X-rays, Melissa alleged the state's withholding of them rose to the level of a Brady violation. In support thereof, Melissa presented an affidavit from her trial defense attorney, Paul DeLuca. DeLuca averred that during the course of pretrial discovery, he issued 2 subpoenas for production of complete case files to the Lake County Coroner's Office. Okay, that's 2 times to the Lake County. That's the coroner's office that had these TIFs in their records. They were found in 2015. They were known to be there in 2009. They were not handed over in 2011 to the defense. Right? Okay, anyway. The entire coroner's file would exclude X-rays taken by the medical examiner during autopsy. At a subsequent status hearing, one of the prosecutors, Christian Bishop, advised the court that there were X-rays, but that the X-rays were not readable or legible. Bishop then tendered to DeLuca a copy of the illegible X-rays saved on the CD in open court, stating for the record that the X-rays are illegible and on the digital. Despite Bishop's representation as to the X-rays' legibility, DeLuca attempted to view the files saved on the CD. He found the CD to contain 3 image files named BK1, BK2, and BK3. The first 2 images appeared totally black or blank. DeLuca noted that BK3 was dark but appeared to be an X-ray of the lower body. These were the only X-rays tendered to DeLuca by the prosecution. Okay, and that's in 2011, and we know that they had the TIFs in 2009, and we know that the coroner's office had the TIFs in 2015. Right? So, okay. Then after trial in 2015, the Lake County Coroner's Office identified and produced a second CD containing 5 X-ray images from Melissa's case. These 5 X-ray images were significantly brighter and more readable. And in this affidavit, DeLuca averaged. So they go on to say how they now use these new images. She brought in new experts to examine those images. And basically, this kid did not have any skull fractures. This kid had a pre-existing injury, and it was being aggravated by re-aggravating it with more head banging. And that's what the proof comes out here. So, all right, so that's basically wraps it up for the main issues on the appeal. So the next bit will be her claims with what the claims that she is now bringing to federal court. I'm going to go ahead and stop sharing for a second. Hello, hello. Okay. What we got? LSD trip here. He seems like a clear case of disingenuous. All right. Well, hey, all right. Not much to say there. Will AEDPA be a big issue in this case too? I imagine it probably will. That the state's going to argue that this is habeas review, and they're going to be saying all the things that all the things that the state of Wisconsin was saying. Most likely, they're going to be leaning real heavily on AEDPA. I imagine that's that much you can count on. But I mean, there's so much dirty pool going on with these X-rays and everything that the state is and the prosecution's pulling in this case. I'm shocked. You know, I don't want my agents of the state, people that I'm supposed to trust, acting that way. Who's to blame for what, L. Fallon? I think I'm sorry. I think Calusinski's in Michigan or Illinois. Obviously, the Wisconsin Supreme Court made a decision that's going to change the way Brady's interpreted in Wisconsin. Oh, well, you heard me reading right there that it was basically this medical examiner's opinion that kind of colored the entire investigation. That's what that kind of thing, the thing I was just reading was getting into. It colored the entire, investigation. It caused them to go after Melissa when they probably shouldn't have, and that sort of stuff. So, and how nobody was looking at these X-rays that showed that there was no fracture is just bizarre. And we're going off of what? We're going off of what one guy claims he felt with his fingers and stuff. It's just really odd, the whole thing. Really, it's weird. Yeah, AEDPA is total crap. No, it was Wisconsin Supreme Court, pom-pom, that made that. That changes it in Wisconsin. My cup was giving me a little trouble because it's a sealable thermal cup. That way I'm able to keep things cold without ice, right? So when I have to screw it back on, sometimes it's like it doesn't want to like line up the threads. No worries, no worries. All right, so those are some of the basics right there of Melissa's case. The fact is that the facts are coming in showing that this kid had a history of banging his head, right? And that is what is and the re-aggravating of that is what has most likely caused him to be deceased, right? And the fact that this would have been obvious in the X-rays and those were hidden. You know what I mean? It's like, it's the same colors. They're desperate to get somebody, and so they hide anything that might point to their innocence. And when our justice system is thinking it's okay to do that, we're in trouble. We're definitely in trouble. So we can't sit by and just say, "Oh, it's okay," you know. Can't sit by idly, accepting everything that we are told, as Mr. Seabrook tells us. Right. Exactly. Like ADPA is going to always be right there. They're always going to use that because it's a. I mean, look, if every time you say walked out onto a baseball field and somebody handed you a special bat that had all kinds of tech in it, that when you walked up to the plate, it increased your chances of success by say 50%. Imagine how happy you would be to go up swinging that bat. Well, that's what AEDPA is for the states. When they get into federal court on habeas review, the AEDPA is like that bat. It's just something that makes their job a hell of a lot easier. It's a crutch, but hey, when you got something there that makes it that easy, they lean on it every time. They'll lean on it every time. Different. It is a slightly different topic, so yeah, it might be a little different. Well, all the games that they're playing with these pictures and these images and all that sort of stuff. Yeah, it's good. I mean, it seems like the fact finding here was not thorough or correct. So, you know, standard is still the same no matter what kind of claim is filed. The state Court of Appeals decision has to be an unreasonable application of clearly established federal law. So there you go. Or Supreme Court law. It's on the state side all the way. Absolutely. Yeah. AEDPA is a turd. I hate it. It robbed us all of one thing that made America great. That was the habeas writ, and it robbed us all because they wanted to kill a very, very tiny percent of prisoners fast. So we all got robbed in the process. It's an absolute turd of legislation. You heard it here first. An absolute travesty. Were all the Brady violations already known when the state's Court of Appeals made their decision? In the most recent one, I have the actual oral arguments on my channel here, where Zellner's arguing in front of the Court of Appeal judges, and they are bringing up all the image stuff. She brings all that stuff up. She argues all of that in front of the Court of Appeals and lets them know all the games that the state was playing, and apparently they were unmoved by it. And so here we go, on to federal court. We do know that she was just recently successful in federal court with one of her clients. So, well, hey, that's the way it is. That's why AEDPA or EDPA, as you hear lots of people like Drizzen and people talk about it, EDPA, but it's AEDPA for those who see it written and get confused. So EDPA or AEDPA is something that should have never happened. It happened out of fear in wake of the Oklahoma City bombing, and that's it. It was just because of fear resulting from that AEDPA came into existence. And when we react in fear like that, folks, we undermine the concepts that the founding fathers laid down to try to keep us and protect us from government, or even at this point corporations and things like that from taking control. And you know, it's up to us to take control for the people, by the people. As long as we don't care, they can do whatever they want. Right? I mean, when it comes down to it, it's really that simple. Melissa is going to have an issue with the same judges that voted against Brendan. Sure. Easterbrook has never overturned a case post AEDPA. Any retirement shortly. Yep, good judge running with vote. So let's go ahead and look at what they're arguing now with what the arguments that Zellner's making with the on habeas. All right. So ground one. Melissa's 14th Amendment due process rights were violated where the state, through its agent, reduced the size and quality of the x-rays saved to the Lake County coroner's computer before producing them to Melissa, thereby effectuating a mere partial disclosure in violation of its disclosure requirement under Brady. In the alternative, Melissa's 14th Amendment due process rights were violated when the state withheld readable copies of the x-rays that established that BK had not suffered a skull fracture, and the state's attorney misrepresented to Melissa's attorney on the record that the only x-rays tendered to Melissa before trial were unreadable. Had the state made readable x-rays available to Melissa's experts would have concluded that BK had not suffered a skull fracture, thereby enabling them to render the opinion that the supposed mechanism of death, i.e. violent force, that caused the skull fracture, was not supported by the scientific evidence. Further, the readable x-rays are material because their disclosure would have permitted Melissa to impeach the testimony of rebuttal expert Dr. Manuel Montez, which included statements about digitally manipulating the alleged skull fracture. Because the readable x-rays demonstrated that there was, as a matter of fact, no fracture in BK's skull, Dr. Montez's testimony to its existence was untrue. Because the readable x-rays impeached Dr. Montez's testimony, they are properly deemed material for purposes in Brady analysis. When evaluating the materiality of the readable x-ray evidence, the state court improperly applied a sufficiency of evidence standard. In so doing, the state court improperly applied clearly established federal law on the analysis of Brady material. The state court's denial of relief on this issue involves both an unreasonable application of clearly established federal law and an unreasonable determination of the facts. So, part's pretty lengthy here. So, supporting facts. On September 7th of 2011, 8 weeks before Melissa's trial began, former Lake County Assistant State's Attorney Christian Bishop gave Melissa's trial attorney, Paul DeLuca, a disc containing 3 x-ray images. Bishop represented to DeLuca and the court that the images were not legible or readable, even though they had images that were at the coroner's office. And she argues how being an agent of the state, by the Supreme Court's determination in past cases, the coroner's office would be considered an agent of the state in this, and the fact that those TIFs are held back, so that's what she's arguing. But anyway, that's a lot what this is about. Is she's arguing that they handed over these JPEGs with this Tiger View stuff, and the Tiger View was meant for viewing the TIFs, but they sent over this Tiger View software with these JPEGs that were horribly manipulated. And then because of the nature of a JPEG, it had literally like 2% of the information that the TIFF had. So when they would try to blow up and look at things closer or whatever, it was a poor resolution image. Basically, it had just very little of the actual metadata and fullness that the TIFFs had. And so that's what they're pointing out here mainly. After Melissa's trial, DeLuca attempted to open Tiger View again. Although he could not open the program on his computer, DeLuca's secretary was able to open it on her computer. When they tried to use Tiger View to enhance the second x-ray image, the entire image appeared white. The state, September 9th of 2011, state filed a supplemental answer to discovery, which memorialized Bishop's production of a CD with 3 digital x-ray images purporting to be of BK, and the program required to view the x-ray images. DeLuca and his secretary attempted to open the program required to view the x-ray images. What was saved to the CD tendered by Bishop on September 7, 2011. program was called Tiger View, and neither DeLuca nor his secretary could open it because Bishop had represented to him that the images were not legible or readable. DeLuca undertook no further effort to use the Tiger View to view the X-ray images before Melissa's trial. Instead, he chose to formulate his pretrial strategy based on arguing, basically accepting that there was a skull fracture because he had no way to contest it. In 2015, the Lake County Coroner's Office located and produced legible copies of the X-rays of BK from his autopsy in 2009. These X-ray image files were not dark to the point of illegibility. Instead, they were bright and, according to Melissa's experts in post-conviction proceedings, clearly showed there was no fracture in BK's skull. The prosecution is responsible for Brady material that is within the custody and control of the state's agents. Based upon the 2015 disclosure of clear and readable X-ray image files, it is apparent that the Lake County coroner was in possession of clear and readable X-ray image files since 2009. Therefore, irrespective of any good or bad faith on the part of the coroner's office or the prosecution, the 2015 X-rays are properly considered withheld for purposes of Brady analysis. As for the materiality and prejudice prongs of Brady, Melissa argues that the pretrial production of the X-rays likely would have led to a different outcome at trial because, 1, they were favorable to Melissa, and 2, they rebutted and impeached the state's expert's testimony. The readable X-rays were favorable to Melissa because they did not show a skull fracture. Moreover, the readable X-rays would have rebutted the state's expert's testimony. Additionally, if they had them, they would have brought in a pediatric neuroradiologist and would have been able to confirm all these things. And then it says, in Kyles versus Whitley, the United States Supreme Court held that to comply with Brady, the prosecution bears the duty to learn of favorable evidence known to other government actors. The coroner's office and its agents are properly considered government actors under the Supreme Court's formulation in Kyles. Therefore, knowledge that readable X-rays were saved to the coroner's computer in 2009 is imputed to the prosecutors in Melissa's case. Because the prosecutors in Melissa's case did not tender the readable X-rays to Melissa before trial, they were withheld for purposes of Brady analysis. Because, as set forth herein and in Melissa's concurrently filed memorandum, the readable X-rays are material and their non-disclosure prejudiced Melissa. The prosecution violated Brady when it withheld them. So this is basically the case that they're making. I've gone over the difference between the TIFFs and the JPEGs and stuff. So B, ground 2, Melissa's 14th Amendment due process rights were violated where the state secured her conviction through the knowing use of perjury. The testimony of Dr. Montez regarding his alleged examination of BK on January 16, 2009 is demonstrably false. Dr. Montez's testimony substantially contributed to Melissa's conviction. The state court's denial of relief on this issue involves both an unreasonable application of clearly established federal law and an unreasonable determination of the facts. At trial, Dr. Montez testified in sur rebuttal that he came to the Lake County Coroner's Office on January 16, 2009 to consult with BK's autopsy. According to Montez, Deputy Coroner Paul Foreman and investigator Mike Young were present at the time of his alleged examination of BK's body. Dr. Montez testified that he saw the skull fracture and felt the fracture. Specifically, Dr. Montez testified at trial that he took his examination gloves off to feel the fracture with his bare fingers to assess the freshness. According to Dr. Montez, he felt a ridge where the two sides of the supposed fracture were not flush, and noted that the supposed fracture did not feel sticky, an indication that the bone had not started to mend. Dr. Montez went on to render an opinion as to the manner of BK's death based on his assessment of the skull fracture. According to Dr. Montez, the presence of the skull fracture meant that BK had been a victim of violent and had been intentionally thrown to the ground with significant force. Dr. Montez ruled out that the apparent head injury was self-inflicted or accidental. Dr. Montez also testified that he examined BK's brain and the bleeding he observed therein. So it's mainly going through now basically just discrediting the prosecution's main witness in this case that would have convinced the jury that this was not an accident, And like I said, the prosecution was playing games here, and they were hiding things. And I obviously will leave a link for everybody to go check this out. If you go to Kathleen Zellner's website, it's right there right now. She's got it up right now. So there we go. So interesting stuff. How many are still with me? Did I lose everybody now? Oh, still got 40 of you. Hello, guys. Only Williams has retired. 3 empty seats when they heard Brendan's case. Flom also recused himself. Which judges have disappeared? Tracy. State of Illinois, right? Okay. Hi, Paula. Hi, Paula. Uh-huh. So what do you guys think about Melissa's case there? What you can tell from just that brief review of some of the issues in it. I mean, you think the state and the prosecution were playing a fair, keeping it above board? Hi, Miss Thing. I watched Casey in court with this case. Yeah, there is out there a video of her making oral arguments with the state appeals court about this and the Brady violation. Another case of hide and seek, absolutely. Yeah, Illinois is trash too. Well, I don't like to go around calling everybody trash, so but I get you guys' meaning. Hello, everyone. Glad you made it back safe. Long flight. Oh, it is a long flight. I do not sit well for 15 hours. I do not sit still for 15 hours very well. That's just not in my wheelhouse. But got through it, I guess. So I'm curious to know your thoughts on why the judges seem to be on Casey's side in that hearing, but ruled against her. Hard to say. Really is hard to say. I mean, they could have been feeling pressure. I mean, I don't know. It's hard to say. Could be personal politics. Could be a lot of things. It's hard to say. They could have been on the fence legitimately and then fell the way they fell. Wheelhouse. Oh, no. Well, like I said, I have it on my channel. It's on KZ. Actually, Kathleen Zellner has a YouTube channel now. It's there along with Exhibit H and stuff like that. So you can find it there. But it's her arguing this whole Brady claim in front of the Court of Appeals there in Illinois. And so it's interesting. It's interesting to watch KZ in action. I mean, look, that is a long time to be interrogated. I'll tell you, I'll agree, but I think it also depends on, how the interrogation is. Is useful information getting extracted throughout it? Or is it all just a big stonewall and then they eventually just start browbeating the person into saying a few things they want them to say? That's the way it usually ends up going at the end of 9 or 10 or whatever hours, because they know they have to do something quick to be able before the prosecution is going to say, "No, we're going to have trouble in court with that, most likely," right? That's what it then tends to come down to. So, right on, Tracy. I hear you. You want to go ahead and read everything? I know. I get it. I just know I heard about all this stuff about the kid, having a history of banging his head and that there was a pre-existing, injury. to the brain. I remember hearing about all this months ago. So the most recent thing was the fact that they were talking about how these JPEGs had been hidden, how these TIFFs images had been hidden, and that sort of stuff. So that's what's interesting at the moment here. I thought I wanted to call a little bit of attention to it. Yeah, I know it gets hard to remember everything. I hear you on that. Totally hear you on that, Trace. That's what I was going to say yesterday. Saying yesterday, some of the judges seemed so much on Laura Nyrider's side, and then the result was, well, it was 3 against. It was 3 for her and 3 against her. You know, you had Campbell. I'm sorry, you had Williams, Robner, and Wood, who were basically for Brendan, and then you had Sykes, Can, and Hamilton, who were against Brendan, and then you had Easterbrook, who was up there and didn't say a word. Do you think the parents had anything to do with the past head injury? From what I've understood, is the kid. I think that the child had a little bit of a temper, and I think would sometimes do that like as a reaction to like being told he couldn't do something or something like that. Is what I remember hearing, but I could be wrong. I thought they completely telegraphed the decision in Brendan's case. I walked out of the courtroom and knew he lost. Well, I obviously didn't have the chance of seeing the faces in the courtroom, so I just had to go with what I was listening to. So I honestly didn't feel great about the chances of Judge Easterbrook going in Brendan's favor because he is on the panel. The bail, the panel of judges that decides whether or not people get bail or get out or whatever, and whether they get held, stay in, and or whether they get released. They're the ones on that panel that denied Brendan. So I didn't expect Judge Easterbrook to really be on Brendan's side, to be perfectly honest. After those hearings, do the judges discuss it like a jury does? I would imagine they do, that they get in a room at least for a little while and talk about it. I imagine it's a lot of interaction between law clerks as well. So, I mean, it's going to be interesting to me to see what happens here. The end, it says, this is an interesting wording. What do you think? It'll be interesting to see Tracy's opinion about this. At the end, it says prayer for relief. Is that normal in a habeas petition? Wherefore, petitioner prays that this court grant her all relief to which she may be entitled in this proceeding, and asks this court, number 1, issue a writ of habeas corpus ordering that Melissa Calusinski be brought before the court to be discharged from her unconstitutional confinement and relieved of her unconstitutional convictions and sentences. Number 2, schedule a filing of legal briefs and memoranda in support of the issues of the law in this petition so that the court may be fully informed. 3, hold an evidentiary hearing as to those disputed issues of fact necessary, and then for the fair adjudication of the issues raised in the instant petition. And number 4, grant all relief to which she may be entitled in this proceeding. So I just thought it was interesting that it's worded as prayer for relief, and then it's respectfully submitted, Kathleen Zellner, that sort of stuff. So I thought that was interesting. Thought that was pretty clear too, but I didn't know at the time how many people he needed in order to win. I wish they had gone back and debated it between themselves. That is unusual. Okay, so prayer isn't the way it normally goes. All right, interesting to know. Good to know. Where the hell is Travis anyway? Where is that slacker? I'm gonna text him. All right. I would think that 3 out of 7 judges wanting to grant him relief would be proof. Actually, if you look at all 8 federal judges that looked at Brendan's case, the judges are split. This is hardly a resounding decision, especially considering that the state had the crutch of AEDPA to help them. And yet it's still just barely floated over the net here, really, to be perfectly honest. Mm-hmm. I think we need to institute a new prerequisite for being a judge or any other elected positions. You must have common sense to be allowed to run. That's funny. Let's see. They have a conference immediately afterward, and the decision doesn't usually change unless one of the judges has a change of heart. It's at the afternoon conference that they assign who is going to write the majority decision. So they have to know which way the vote is going to go. Right. Makes sense. So, like I said, a little bit of stuff to look forward to here, following along with some of other Zellner's cases, folks. I know Tracy was talking about that in her video there before I went on, about we're in a holding pattern and stuff. Well, folks, whenever you find yourself in a holding pattern, you can take an interest in another piece of criminal justice. You know, you can do that. I know I've taken interest in a few different pieces of criminal justice that have bothered me. And most of that has been because I was in a pattern where nothing happening with Stephen and Brendan at the time, and got kind of pulled in and interested by another case. And the more we do that, the more we make ourselves aware of, the more we talk about it, folks. Keep talking about it. Keep stoking the fires that these really, really great documentaries have created, that have started. And we got to keep maintaining it and keep, fueling those fires and maintaining those fires and keeping them burning so that the issues don't go away. So what is KZ's YouTube channel? See, that'll probably show up here in a second. So hopefully we'll all be watching and checking out what's going to be going on with Melissa Calusinski. I'm going to go ahead and check out at this point. There is one. It's called, it might not even be made by Zellner. It might be made by somebody else who just used the name Zellner, but I know that's where I found it. Anyway, here nor there. So I'm going to go ahead and finish this one up. I know Allie's looking to go live, so I'm going to go ahead and let her get up and go live, and then I can go and leisurely comment on her live. So just wanted to talk a little bit about Melissa Calusinski today. Obviously want to call people's attention to making sure you take an interest in more than just, I know it's easy to get stuck on just Stephen and Brendan and not wanting to look outside the blinders, but I mean, there's more to look at. And by looking at it and finding it in other cases, it only adds to your ability to argue that the things that you see in this case are bad, because you can see in other cases where these things happen, and it's proven that it's not good. It helps to prove that these things aren't good for the criminal justice system when we're all paying attention to them happening across many cases. And we continue to call attention to that. Those are the things that are going to help in the end to make effective change. And as Dean Strang said, what do? We talk about it, and we continue to talk about it. So, all right, I'm going to step aside, go ahead and sign off for now. Let Allie go on, and look forward to seeing you all over there on Allie's live. Make sure you show Allie your love. We all love Allie. We all love Tracy, basically a lawyer. So those of you who haven't, just subscribe to her channel as well. I always want everybody, the supporters, to be well informed. And trust me, if you're listening to people like me and Tracy and Allie, you're getting well informed, and you're getting truth, a lot of truth. And so, like I said, all right, that's about it. I'm gonna step aside here and take care of something real quick, and then get ready for Allie's live. So you guys, we'll see you there. If you haven't already, please hit subscribe.